Hi, everyone. Hi, welcome back. Welcome back. How's everyone doing today? Everyone had a nice off day. Yesterday, I had a crazy day. I did a unintentional college road trip. I was giving a talk yesterday at noon at Baylor, and I was going to a conference in Austin for dinner. So, yeah. So basically, I left really early in the morning. I made it to College Station. I'd never been there before. I went to the Bush Presidential Library, which was really nice. Which one's at A&M? Yeah, W is at 43 is at SMU, right? And 41's at A&M. So no, be nice. So I went there. It's actually really cool. Shh, everyone settle down. If you haven't been, I'd recommend it. You can actually sit in a replica of the Oval Office. You can actually sit. I have a picture too. You can actually sit in the chair. It's not the actual chair that the president sat in, but the president has sat in that chair. If you get my drift, right? Yeah. Yeah.
Isn't it neat that he didn't use the resolute desk, he used the vice presidency desk?
Yeah, I mean, it's interesting. I mean, at the LBJ library in Austin, they have a replica of the Oval Office, but it's behind glass, and like you have to stand 5 feet away. You can't even really see most of it. So I like the 41 library. I drove past Kyle Fields. I did my little road trip. I saw the stadium, which was nice. Then I hauled butt to Waco, and I got there like 11:30. I gave my talk at Baylor, which is a beautiful new stadium. That's a really, really nice. I love. No, it's a nice school, but what's cool about it is the actual Brazos River comes up to the banks of the stadium, and you can go tailgating. You actually bring your boat right up to the stadium to go tailgating. That's pretty cool. So I was there for like 2 hours, and then I drove to Austin because I had a conference thing at Austin at the law school last night, and then I drove back to Houston. I got back around midnight. So, but I got plenty of energy, ready to roll. This isn't even that bad. There will be one day this semester where I take a red eye and it comes straight from the red eye. I won't tell you when that is. Maybe you can figure it out. This one actually isn't too bad. I like local travel is good. I also get an airplane. This is actually fairly easy. All right. So yes, I saw Kyle Field, McLean Stadium, and Texas Memorial all in one day, which I don't know if that's a record, but it's a lot of driving. Okay. Let's see. Anyone else do anything fun yesterday? No? All right. Well, I think I win then. Okay. I usually will. Okay, let's see what else. In case anyone's interested, today at 6 if you're around. Oh, wait a minute. Oh, 12:20. Why did I say 6 o'clock? In case you're around, and it was originally at 6 o'clock and made it at noon. So in case you're around right after class, there's going to be a discussion on immigration on the 6th floor library. And if you'd like to go, I encourage you to check that out. There's going to be someone from the Heritage Foundation who's going to be quite conservative, and someone who's a local immigration lawyer. So you'll get a nice blend of views on this important salient topic. Okay, I don't put them up there. Those are very helpful when they put them up there. Okay. All right, so let's go back to future interests. Okay. Before I get started, as always, any questions? And if you do, I'll probably answer it in about 5 minutes. Anything lingering in your mind, anything bothering you? All right. So again, this topic is truly a building blocks topic. Okay, what do I mean by that? Each class build on another layer from the previous class. And it's very, very important for you not to fall behind. I hope to date, you at least are able to fill in the first 3 rows of this table, right? You may not do it from memory, but at least if you're looking at your notes, you should be able to fill in the different boxes and understand why each column is what they are. The reason why, I'm sorry, the first four rows. The reason why is that we're going to start elaborating on them. Okay. To date, we've been fairly vague about the future interests, but today the future interests get a lot more specific, and they get even more specific in class on Monday. All right. So to start class off, I want to start by filling in this table. And we're going to keep coming back to this throughout class and adding to it and modifying it. And this will be like your Bible for future interests. And you can use this, you can use whatever you want. I really don't care. But I find this flow fairly helpful, and I hope you do too. All right. So let's see. Where did I finish last time? Right there. Okay, back there. So okay, Judson. All right, we'll start off the easy ones. Okay. So what I want to do is recall the first column lists estates, and I've said this a dozen times, but when you ask yourself what's the estate, you ask yourself who owns it and when do they own it, right? And the specific question of when is either a present interest or a future interest, right? Either you own it now or you own it in the future. We don't care about the past. The past is gone. So you either own it now or you own it in the future, right? And what makes this topic so complicated is that present and future estates differ depending on the nature of the estate. There's not just like present estate and there's future estate. There's different names for everything depending how long it lasts for. And there are certain magic words which we use to describe these estates. And these are words which you all have to commit to memory. There's no way around it. When you see these words, a little red flag go off like, oh yeah, that means fee simple. Oh yeah, that means remainder. You need to know these things very straightforward. So let's start with the most simple and we'll work way down. So Judson, let's walk me through the fee simple, right? How long does fee simple last for? Forever, yes. This is the easiest one, okay? What are the words we use to describe a fee simple, Judson? Okay, right. So for example, A and his heirs. This is nothing new. When you see to A and his heirs, you know, boom, fee simple. You know, piece of cake, right? Okay. So Judson, in this case, all right, like this. In this case, Judson, who has a future interest? Of, exactly. A's heirs have the future interest. Does O have any interest whatsoever?
No.
How come O has no interest? No. That's not the right answer. How come O has no interest? He gave it all away. Okay? The thing about a fee simple is that when O gives away a fee simple, he gives away all the sticks in his bundle. He gives away everything. He retains nothing, right? So O has no future interest. Okay? I'll just write INT, you know what I mean, okay? No future interceptions or interests. All right, everyone get that one. That one's straightforward. All right, Gary, walk me through, please, the second row. This is going to be for life estate. So what's the duration of a life estate? Okay, well, be precise, it's the life of the grantee, or I'll say transferee, right? So what are the words to describe a life estate? How do we write it out? Good. And we know, we've said this before, O is a transferor and A is a transferee, right? Me receiving. So it's for the life of the transferee. So the duration of the life estate is the life of A. Everyone get that? Okay? And Gary, what do we call the future interests for a life estate? Yeah, how would we describe it?
I know that they go, that O has a future interest.
What do you call that?
A reversion.
Okay, that's right, okay? For the example we have here, from O to A for life, O has a reversion. Gary, how do you know it's called reversion? You have the right answer, but I think you're a little tentative. Why is the answer reversion? What?
It was a guess.
Okay, let's try a summer. Gary's right. O has reversion. Why is it called reversion? Explain the thought process to me there.
You're going from O to A and then back to O.
What exactly, okay, what does O have to start off? What's O's initial estate at the very beginning? What does O have at the outset? Louder, you're right. That's right. So O starts off with a fee simple. What does O give to A? Does he give him a fee simple? What does he give? What's bigger, a fee simple or life estate? That's right. We think of it that the life estate is kind of like a slice of the pie, right? If like this is fee simple, life estate it's like this, right? Or if you want to talk in terms of the bundle of sticks, right? You have, you know, your fee simple and you carve out a life estate, right? So what happens, Summer, when A dies? What happens to A's interest? Exactly. There's a reversion to O. So once A dies, there's a reversion to O. So the future interest, and for this example, is O has reversion, or a reversion if you want to speak English. Everyone see that? Any questions about that? Okay. I'm going to give a different variation of this one. So I'm going to say from O to A for life, then to B and his heirs. Okay. So Rhiannon, tell me. Oh, please, Summer. Yes, go ahead.
Transferree, is that synonymous with grantee?
Yes, yes, yes. Whenever you see the word EE at the end, it's the same thing. That's the person who receives it. The book calls it transferee, so I'm going to use that word. That's how the book describes it. But grantor, grantee, it's the same thing. There's no difference. I try and go with what the book says. I prefer what you said. I prefer grantor, grantee, but I'll stick with what the book says. Okay, Rhiannon, let's take a look at this example, right? From O to A for life, then to B and his heirs, okay? So what's the present estate called here? Okay, and who has it? Okay, A has it. And how long does it last for? Yeah, okay, so that's exactly the same. The life estate that lasts the life of A. Same exact thing, okay? Now, it's a slightly different situation. Does O have any future interest in this case? That's correct, okay? Why does O have no interest? Well, be precise. What did he give away? Okay. Let's walk through this one step at a time. What do you call, you're right, but not immediately right. So what do you call B's future interest here? How would,
It's a remainder.
okay, a remainder in? Okay. So B has a remainder in fee simple. That's exactly right. Okay? Everyone see this? Rhiannon, why is this called a remainder and not a reversion?
Because it's not going back to O, it's going somewhere else.
Yes. Okay. So here's one lesson which you simply have to memorize. Reversion is for the transferor. Okay. Remainder is for a third party. I'm going to tweak that a little bit later, but for now, you need to remember these two things. When you have a life estate, okay, when you start with a life estate and the future interest goes back to the transferor, it's called reversion. When you start with a life estate and the future interest goes to a third party, it's called a remainder. If anyone doesn't see that, stop me. You need to know the difference between a reversion and a remainder. If you don't get those right, you're going to be in a lot of trouble. When you have a life estate and the future interest goes to the grantor or the transferor, it's called reversion. When you have a life estate, here, I'll write it out very clearly. This way we know it, right? You have a life estate and the future interest is in the transferor, it's called reversion. Okay? When you have a life estate and the future interest is in a third party, it's called remainder. Everyone gets that? Yeah.
Is this only for life estates?
99% yes, and I'll get to that in about 10 minutes, but 99% the answer question is yes. Yes.
On Monday, in the example for the second part of the remainder, we said from O to A for life, then to A in his heirs. What's the difference between then to A and then to B?
I'm sorry, repeat. What was the example?
Would you mind going back to the chart so I can show you?
Yeah, sure.
Right there where it says from O to A for life, then to B in his heirs.
Okay, this one, yeah.
On Monday, we have B replaced with A, and I don't see the difference.
I don't remember that example. If anything, that might have been.
To A's heirs.
Oh, to A's heirs. Oh, that's different. Oh, okay. No, that's different. Okay, so we can make that the same way. So I'm going to make this from O to A for life, then to A's heirs. Right? Is that the thing we did on Monday?
Yeah.
There's no difference, right? So Summer, let me ask you, in this example, who holds the remainder? Summer? No. Who has the present estate? A's heirs. Yeah, it's the exact same thing. In this case, A's heirs And actually, it'd be A's heirs and their heirs if you really want to be precise. That's why I don't like this example so much. But you can have remainder in someone's heirs. So let's take a thing. So you're A, right? You have it for the rest of your life. And then when you die, your heirs have it in fee simple. Right? Everyone see that? I'm going to go back to how it was before because I don't like this example because it's too confusing. So undo, undo, undo. Okay. I'm going to keep it like this because this example is a little bit easier. Yeah.
It's almost like
Yeah.
he's giving him a fee simple because it's still going to his heirs, but he's the difference there that he doesn't want to be able to transfer it.
Don't ask me that question yet. This raises the rule against perpetuities, which we're going to cover in about a week. I know you're the example you just asked is feasible, but it's very tricky. So ask me like in like a week, okay? But the problem of what she just said was that people wanted to cut out their son. That was frowned upon by the feudal lords. So they got ways around it. But let's leave this example for now, okay? There are problems with that one, which we can deal with later. Let's keep it simple, okay? All right, so from O to A for life and to B in his heirs. And we say that B has remainder in fee simple, okay? What's important to remember at this one, right, is that O started off with a fee simple, right? He carved up his entire pie. He gave his entire pie away. He gave a life estate to A, and then the rest of the pie, a remainder in fee simple to B. What's important to remember is that O retained nothing for himself. O has no interest. O's got zilch. Everyone see that? Everyone got with me? If you don't see this, raise your hand, please. Okay. All right, let's move on. Okay, and this is nothing new. We did this all last week, or last class. Okay, let's talk about a fee simple, a fee simple determinable. Okay. All right, Ashley, walk me through what is. Let's start actually with the. Give me an example of what a fee simple determinable will look like. That's often the easiest way of doing this.
The words are so long as, so they give the property so long as.
Okay, good. Yeah, perfect. So let's say from O to A, so long as used as a church. You know, most simple example. Okay. So then actually, you already answered it, but what's the duration of a fee simple determinable? How long does it last for? Yes, right. It lasts for some durational word, right? And here's your cheat sheet. So long as, while, during, until. These are all synonyms. If you see one of these words, right, that measures duration, a length of time, you need to have a flag go off in your head saying, oh, wait a minute, that's a fee simple determinable, right? You have to memorize this. There's no way of getting around this one. Okay? All right. So actually, and finish up the column, when the present states a fee simple determinable, right? Right, we know that A has a fee simple determinable, right? What do we call O's interest? Yes. O's future interest is called a possibility of reverter in fee simple, if you want to be really precise. Actually, how do we know that O has a possibility of reverter in fee simple? How do we know that? Oh. Let's see, Troy. Why does that's fine? How do we know that O has a future interest in possibility of reverter?
He started out with fee simple,
Okay.
and he didn't give away all of the money.
Yes. So look at it this way, right? O had the entire pie. He only carved out this simple. I shouldn't say the word simple. He only carved out a fee simple determinable, the single estate, right? He left the rest for himself at some point in the future. So when this condition is no longer true, when they turn this church into a bar, right? The condition expires, okay? And then he regains it in fee simple. But while he's waiting, the interest is called a possibility of reverter, okay? You need to remember this by heart. Fee simple determinable matches with possibility of reverter. Memorize that. You can say FSD, POR, whatever you want a way to memorize it. But when you know that the present interest is a fee simple determinable, the future interest is called a possibly reverter. There's no way around that. You need to just have that cold in your head. Okay? Okay. And one other aspect, Meredith, of the possibly reverter. What happens the day that the church is turned into a bar? Who owns it at that point? Does O have to do anything? That's right. The possibly reverter is automatic. Automatic. No steps have to be taken by O to reclaim the land. Okay. The second that church is turned into a bar, boom, it's his. You don't have to go to court to actually quiet title, but the legal date is effective of when that church becomes a bar. Yeah.
I wanted to ask you last time, why is that better?
Because what happens if the grantor never actually goes to court, and then the grantor dies, right? Then his heirs would have to go to court. It delays the inevitable of when you get the property. Or what if, say, you're the heir of O, and O, for whatever reason, never goes to court, right? If he never goes to court, you have to wait till he dies, and then you get to it. So it delays what can be done with the property until you actually go to court. It speeds it up.
But you said you don't really have to, it's automatic.
So you do, because you would actually need a judge to say, yes, you own it, right? As a matter of law, they just say, as of this date, when it became a bar, you were the legal owner, and I'm going to pronounce you that, right? You can't just barge in and change the lots automatically. You need to have some sort of judicial declaration. But there's no,
What's the difference between that and the entry? I mean, the date, why does
there are certain legal proceedings that have to happen that are much more strenuous, right? In the case we did last week, the Marinholtz case, it actually made a difference of whether the guy actually took the steps to enter because it hadn't been done yet. Or if there's a change of heart, maybe they don't want to. It makes it a lot easier for a person in their heir to this property, right?
That doesn't really affect the date. That's why I'm asking.
It will affect the date on which you owned it, which actually might make a difference for a lot of things like taking a mortgage on it, taxes, other things, right? Ownership at a certain date is significant.
So you get to have a mortgage from the time they changed it instead of the time.
In theory, you can actually get a mortgage on the land when you own it. Yeah. If the bank wants to write you a mortgage for the judicial declaration, they could do that.
Okay, so the guy could go apply for a mortgage and a court date at the same time.
Yeah.
Okay.
It speeds up the process.
Yeah, that was exactly my question.
The differences aren't big, right? But you do need to know the difference that steps have to be taken.
Stop them from adverse possession claim?
Yes, so that's actually one difference, right? Say the property changes over, right? You are now having to squat against someone else, and the clock restarts. You haven't studied adverse possession yet, so you know what that means. But if someone's squatting on your land, and then you obtain it, you need to start squatting against someone else, and that restarts the clock that's necessary. Don't worry about adverse possession, though.
Okay, that's why I was asking, because they were saying that statute of limitations start from the murder or declared in court, but then they said most courts won't get to that.
Yes. The difference is not big. Don't worry about that. Okay? All right. So let's go on to the one where it does make a difference if you take legal steps. Right? So let's do, Adriana, let walk me through the final row we'll do for now. The fee simple, subject, condition, subsequent, right? Give me an example of what a fee simple, subject, condition, subsequent would look like. I'm sorry, a little bit, I can barely hear. Louder? Good, okay, so we'll use that example. From O to A, but if not used for school purposes, keep going, then what? Okay, right, then O has a right to enter. Okay, so what makes these two different, right? The fee simple determinable and the fee simple subject and subsequent is the language. You'll see here that the word so long as is used, right? We said that's a durational word. Here, we have these other words like conditional words, like, for example, but if. You might remember from your high school logic class, like, if this, then that, or but this, not this, whatever, right? We have these conditional words, and I'll give you a list of them, and there's probably more, but these are the big ones, like but if, however, on condition that, and there are probably some more, but that's good enough for now. When you see one of these words in a grant, okay? When you see one of these words on a grant, you know that you're dealing with a fee simple subject condition subsequent. Okay? So the present estate, right, is A. A has a fee simple subject condition subsequent. Everyone see that? All right, Samantha, what interest does O have? Exactly. O retains a future interest, and this one's called a right of entry, sometimes called a right of re-entry, but it's the same thing. Okay, and again, O started off with fee simple. He carved out this fee simple subject condition subsequent. We left the rest for himself. And once that condition's breached, it comes back to him, right? It comes back to O. Okay, and as we said before, Cassandra, does O have to take any steps in order to retain the land legally? Yes. Okay, and it's not automatic. So one answer to Rhiannon's question, which I'm not crazy about giving, is that in some places there's a statute of limitations that say you have to retake within a certain number of years, right? That's not the case everywhere, but in some cases you have a statute of limitations. So say you forget about it for 20 years, and you burn your statute of limitations. If it was a fee simple determinable, you have owned it already. If you had to take legal steps to re-enter it, you didn't do it within the statute, you burn it, right? Not everyone has that. I think the Illinois book said they have like 30 or 40 years or something, or the case we did on Monday. So in some places, they've actually put limits on how long you can take to re-enter. Most cases, it won't matter. But if there's something that's really dragging on, it actually might make a difference. But that's not a complete answer, because at common law, there was no statute of limitations for this, so it didn't matter. As a matter of statute, some states have imposed that. Okay?
Okay, and so if you, so I know I addressed this last time, but I didn't really get a straight answer. If you, which is fine. So if you're the tenant or whatever, the person who has the condition subsequent, blah, blah, blah.
Mm-hmm.
If you're there and you change the thing, so
Change what thing?
like let's say I don't use it for school purposes.
Right.
I want to open a bar, and but I know about that of the right to reentry. Like, is there a way that I can go to court and just be like, so are you going to reenter or not? Do you have a problem with this? Because
No, you'd have to wait till they take steps to reenter. I mean, if they choose not to reenter, they lose it. That's their loss.
Right, but so
You can't force them to. No, you can't force them to.
to enter or not.
No, and in fact, you have to wait till they do it. And if they don't do it, that's hovering over your head forever,
Okay. That's
or until a 40-year statute of limitation runs out. So it's actually a very dangerous thing with the condition subsequent. You can be waiting for who knows how long. And at any time, if there's no statute of limitations, they come in and it's like, poof, you're out.
And if they like, let's say if I ask them like, hey, I know you said you have a right to reentry, but like, are you going to use it or not?
You can buy it from them.
Okay.
Right. You can have a settlement where you say, I'm going to give you $1 million if you waive your right of reentry. If you basically you assign your right to me, and that's fine.
Okay.
If the grantor and the grantee are able to come to an agreement, then you can just invalidate this entire condition.
All right. And if they're like, yeah, just
We want to play. We want to taunt you, right? We want to. Yeah. I mean, this is a way you can basically torment someone indefinitely by saying, oh yeah, maybe we'll do it tomorrow. We won't. It's actually it's a very serious issue when this is hovering over your head, because you can't force them to reenter.
That's a tricky situation. But can you as like can you sell it? Can you leave? Can you?
Well, if you sell it, it's still subject to the condition. The only way that condition's released is if the grantor releases it, or his heirs. So it's basically there forever. Property's rough. Yeah, these are rules that were invented to have very certain divisions of property. Okay.
Okay.
Okay. So everyone get this. This is actually nothing new. We spent 30 minutes, which was actually a very good review of what we did last class. So everyone get this. So in the Illinois case we did last week, under the common law, the answer was no. The only way to transfer was to inherit it, right? Under the modern law, and I checked this in Texas, you can. So that's more of a modern trend that you can transfer during life a future interest, like the possibly reverter or right of reentry. So no, the answer is under the common law, the answer is no. Under the modern law, the answer is yes. I mean, that's the answer. And you can decide accordingly. All right. So everyone get this chart. This one, again, you should know cold. You should be able to fill it in very easily, okay? We've actually, believe it or not, covered everything that was in your reading for today. You just didn't realize it yet. See, I was very sneaky like that, right? James maybe picked up on this. I've been teaching you quietly about future interests along the way, and you probably didn't realize it until you did the reading for today. And I did this deliberately. I tried a couple years ago not to do this, and it made no sense. So I was sneaking it in, okay? Now, we're not going to talk about executor interest today at all. Don't ask me about it. We'll do it in the next class. I don't like how the book randomly mentions executor interest and doesn't explain what it is. You'll get to it in the next class, so don't ask me about it now, okay? So believe it or not, we've actually learned 5 out of the 6 interests that we'll be talking about in this class, okay? And the book lists them like this, which is fine. It says, so it divides like this. The interests retained by the transferor and the interests created in the transferee. Okay? Well, I can't spell today. It's that time at A&M or something. I don't know. Oh. Harsh, right? Sorry. I was trying to type Baylor A&M. I was like, who do I have fewer of? Okay. So, real talk, yeah. So we have the interest retained by the transferor and the interest retained by the transferee. I'm going to modify this and put in parentheses a third party. Okay? The reason why I put third party in parentheses is because when it says from O to A, then to B, it's obvious that B is a third party, right? That's who you think the third party is. But you might think, wait a minute, who's a transferee, A or B? Unclear. So for today, I'm going to use the interest in the third party, and I think this will help make a lot more sense. All right? So the book lists 3 different interests retained by the transferor. Okay? So reversion, possibility of reverter, and right of entry. Okay? We've done all 3 of these, right? And so now, as a check to see if you've actually learned what you have, let's see if you can go backwards, right? If you know, right, that the future interest is a reversion, what's the present interest? All right, Jacqueline, let's try if we can do this, okay? You can cheat and look at your table if you like. Let's try without it, okay? If we know the future interest in the transferor is a reversion, right? What's the present interest?
The life estate.
Yes, exactly. Okay. PI, present interest, right, is a life estate. We did this before 5 minutes ago, right? Right? From O to A for life. Period. That's the example. From O to A for life. We know that A has a life estate in present, and then after A dies, the future interest, reversion, goes to O. That's not bad, right? What about, let's see, Ashley, if you know that the, if you know that the future interest is called a possibly reverter, right? What is the present interest called? Exactly. How do you know that?
Because it's based off whether or not the present interest is a fee simple so long as they use it for whatever the purposes.
Yes. So it looks like this, right? From O to A, so long as whatever, right? This is what I mean. You need to be able to look at any of these 3, right? See, oh, from O to A, so long as, you know, the future interest is a possible reverter, the present interest is a fee simple terminal. You need to be able to translate that. All right, so far so good, right? Okay, and then let's take it home, Allison. When you know that future interest is a right of entry, what's the present interest called?
Fee simple subject to conditions.
Exactly. And I implore you, do not write FSSCS. Don't do that. You can do it in the exam if you want, but don't do it now. Actually learn the name because you'll forget what it is. And so just write that now, okay? When you know the future interest is a right of entry, you know that the present interest is a fee simple subject to condition subsequent. Everyone with me? Okay. All right. And an example of this would be like from O to A, but if it's a bar, right, then O has a right of entry. Okay. Now, you may or may not have realized this, right? But in all three of these, right? Let's go to Brian. Brian, in all three of these, who has a future interest?
The transferor.
Yes. Oh, exactly right. In all of these, the future interest is in the grantor, which is O. Okay. That's why the heading is the interest retained by the transferor. Okay. Everyone with me so far? The next category of cases is not created in the transferor, it's when it's in the transferee. Okay, everyone with me? And we've already done this. So I'm going to give you an example to error. So we did this 5 minutes ago. From O to A for life, then to B and his heirs. We did this example 15 times, right? Okay. So Eric, what's the present interest here and what's the future interest here?
Present interest is A has a life estate.
Good.
Future interest is future simple for
Don't say future. What's the future interest called? What's the name for it?
remainder and fee simple.
Yes. Okay. B and his heirs have remainder and fee simple. Okay. Now we've done this a dozen times. I want to really focus on this example because we're going to break it down in a bit. Okay. Let's see, Christian. How do we know that B has a remainder and fee simple here? Why do we know this?
Because why do we know it's a remainder?
Yes.
Well, I mean, it says so to.
I know. I wrote that. But yeah. How do you know it's a remainder, right? If I had just given you this sentence, how do you know it's a remainder?
It's going to a third party. So it's
Okay.
not going back to the transfer.
Okay, so now I need to put some clarification on this, right? I haven't had you study executory interest yet, but you may have noticed that there are other times when the interest goes to a third party, it's called something else. So I want to be very clear right now. What makes something a remainder, right, is when it follows the natural termination of some sort of previous estate. What do I mean by that? And Amanda asked this question, which I kind of dodged before. In virtually every single case, when you start off with a life estate, followed by some interest in a third party, right? And this is not 100%, but like 99%. When you have a life estate plus a future interest in a third party, it's going to be a remainder. Right? This is exactly what I wrote, 5 minutes ago, right? When you have a life estate with a future interest in a third party, it's a remainder. Okay? Everyone get that, right? But when you have, say, a fee simple determinable, actually I shouldn't say that. When you have something other than a life estate, plus a future interest in a third party, it's not called a remainder. This is what's called an executory interest. And I don't want to talk about executory interest except for this one point. What makes something a remainder is that it follows a life estate. Okay? If you make something, if you have a life estate plus some other type of future interest in a third party, you're going to call it a remainder. If you have something else, something other than life estate, and we'll do that in the next class, it's basically executory interest, right? The fee simple subject to executory interest. We haven't done that yet, but you know it exists. It's not called a remainder anymore. The future interest is then called executory interest. This is an annoyingly tedious point, but you need to grasp it. So for now, for the rest of the class, right? I promise you, the rest of the class, Whenever I ask you what is the answer for future interest, you're going to tell me remainder. Okay? Just for today alone, the answer to every question I give you will be remainder. Now, there'll be different kinds of remainders, but the answer is always a remainder. Why? Because every example I give you today will start off with a life estate or something close enough to a life estate. Okay? Everyone get that? So we go back to our example again here, which we've done a dozen times, right? From it's actually from O to A for life, then to B and its heirs. Well, we know we're starting off with a life estate. So you know in your head, oh, when we're starting off with a life estate and it goes to a third party, that must be a remainder. Stop me if you don't get that. That's the key takeaway for now. Was that so clear? Everyone gets it? This is not easy. I make no pretenses. It's not an easy topic. When you have a life estate, the future interest when it goes to a third party is called remainder. All right. Any questions on that before I move on? Yes.
What would be like a good example of like your third party? Someone that's not an heir.
B. Right. There are three names up here, right? There's O, there's A, and there's B. Right? B is literally the third party. He's number 3 in this case. You can have 3, 4, 5, 6, 7. What I mean by third party is not A. In other words, you have O, A has his life estate, and all the people come afterwards, they're third parties. Actually, I saw you were fidgeting with hand. Was that a question or no? Okay. Anyone else? All right, let's okay, let's try. Okay. All right, let's it's good for now. We'll do some more examples in a minute. But everyone get that. When you have the life estate and then it goes to a third party, you're calling it a remainder. Comprende? Okay. All right, because now we have to make this more complicated. Okay. There are 2 types of remainders. Okay. There are 2 types of remainders. And we need to be able to know both of them. And actually, there are more than 2 types, but for now, we'll do 2 types of remainders. Okay. So in this case, let's see, Elise, is there any conceivable circumstance, any possible reason imaginable when B's heirs will not take it? B and his heirs. Is there any possible circumstance where it won't happen? Have you solved the clue to immortality? Have you found the fountain of youth? No.
Okay.
What is the likelihood, percentage-wise, that B and the heirs will get it at some point in the future? 100%. Everyone see that? There is a 100% chance that B and his heirs will get this land. 100%. At least, why do we know this? Yes. You don't live forever, right? A will die at some point. We don't know when. It could be 120 years, but he's going to die. B might be dead, but B has heirs. Maybe B's heirs die and their heirs take over. But the point is, at some point, someone to the right of the comma, right? We have our important comma. At some point, someone to the right of the comma will be alive and A won't be. There is a 100% chance, right, that B and his heirs at some point will take it. All right, everyone agrees with me? No one? Okay. This is what we call a vested remainder. And you'll see this word vested in a lot of legal terms. But vested basically means certain to happen. You might see the phrase vested rights or vested property interest. That means something is certain. It's something to do with, like, a suit and a vest, right? Vested means something is certain to happen. Okay. When you see a remainder, you need to be able to determine whether it is a vested remainder. Okay. So how do you know if something is vested? Okay. There are 2 rules you need to remember, and again, these you have to memorize. There's no way around it. First, it has to be given to an ascertained person. Okay. Generally speaking, what does it mean to be an ascertained person? Someone is named. Okay, this is your trick. Ascertained means identified, right? So a named person is identified. What do we mean by this? Well, it says right here. I'll write it again to make it easier. From O to A for life, then to B and his heirs. Right? In this example, B is named, right? You know his name is there. B's there. He might die. We all die at some point. But when you name a person, the heir is ascertained. The person is ascertained. Okay? We know who B is. So this is an easy trick. If you ever see a person named, and in this class you name people with one letter, right? But if we see A, B, C, or D, that person's ascertained. Okay? Everyone get that condition. Okay? So you need two things in order to be vested remainder. So the first one is to give it to an ascertained person. That's the easier one. The harder one, okay? It's not subject to a condition precedent. Okay? Right? And I'll put in parentheses, other than death. Now, we've said many times this word, fee simple, subject, condition, subsequent, right? Fee simple, subject, condition, subsequent. We've said this word over and over again, right? What does, Catherine, what's the difference between precedent and subsequent? The words precedent and subsequent.
Precedent needs to happen before.
Good.
And subsequent happens after.
Good, right? This is simple vocabulary which you should have studied at some point, but I'll spell it out for you because I assume you come to law school with not much, which is generally a dangerous assumption, but I make it anyway. Precedent means before, subsequent means after. Okay, so let's go up to our table before. This is in your notes. The fee simple, subject, condition, subsequent, right? And I gave you this example. Okay, from O to A, but if it's not used for school purposes, right, then O has a right to enter. Right, this is an example you gave before, right? So Catherine, where is the condition, right? Actually, be more precise. Where is the condition, before or after the grant? How do we know it's after?
You take a stab at it and say there's that after the comma, so the land has been granted and the condition.
Yes.
has to occur after.
That's right. The comma is not the answer, but it's a crutch. Okay, and I will make sure I was typing this quickly, so I wasn't paying attention. But the comma is a crutch. But think of what's happening. From O to A, right? That itself seems like some sort of fee simple, right? I mean, you could even say it like this if you want to be really precise. But I usually don't do shorthand, right? From O to A and his heirs, comma. But if it's not used for school purposes, then O has the right to re-enter. So from right here, we know it's from O to A and his heirs. That looks like a fee simple, right? But it's not just any fee simple. It's a fee simple subject to a condition subsequent. It's a fee simple subject to a condition that comes afterwards. Ah, that's literally what it means. You have a fee simple that's subject to a condition that comes afterwards. Ah, clicking, right? The condition comes after the fee simple. That's why it's called a condition subsequent. Everyone see that? I didn't quite mention that last week because I didn't want to confuse you with more than you needed. But now you'll see the difference. Here, the condition comes after the comma. You give someone a fee simple, but it's subject to this condition. Okay? Let's contrast that to the other kind of remainder, right? So I said there's a vested remainder, something else called a contingent remainder, right? And the issue with a contingent remainder is that it is usually subject to condition precedent. And let's try and give an example. Okay, so let's try this one. Okay, so O conveys, so let's try this one. Okay, so O to A for life, then to B if B becomes a lawyer before A dies. Morbid, right? try this one, right? So from O to A for life, then to B, if B becomes a lawyer before A dies. Okay, so let's walk through the example. Okay, so Eddie, let's start off here, right? What is A's estate? This one's the easy one, right? Okay, A has a life estate, right? Eddie, what did we say 5 minutes ago? When the future interest goes to a third party following the life estate, what do we call that the future interest? Okay, so we know that B has a remainder, right? But we have to be very precise. We're not just going to call it any remainder, okay? We have to look at our two rules. So the first rule, Eddie, was, is the third party ascertained? Do you know who that party is? Who is that person? B and his heirs, right? So the first condition satisfied, right? We know that B is ascertained because he's named. But now we go into the second one. This is, like you said, you teach logic. This is the second one. Is there any kind of condition precedent for B to have the land?
If B has become a lawyer.
Yes. Does B get it and then there's some condition afterwards?
No,
What's the only circumstance where B gets it?
only if B becomes a lawyer.
The condition has to happen before he gets it. Okay? What this means, so I'll just do one. B is ascertained, right? There's no dispute about that. But there is a condition precedent. And then Eddie, what's that condition precedent that comes before? Yes. B must become a lawyer. Mushy lawyers, right? B must become a lawyer before he gets it. So you see the difference. In the previous example, you get the church and you keep it until you turn it into a bar, right? Here, you don't get the land until you become a lawyer. The condition happens before. This is a condition precedent. Pre is before, a condition precedent. Okay? When you see that the condition comes before, and you can tell this with the commas, right? To O for A for life, then to B if B becomes a lawyer, right? The condition's right there in the grant. It's right there in the grant. Let me write this a little bit differently so you can see the contrast, right? Okay, let's try this one. From O to A, but if B doesn't graduate law school, O has right to reenter. Oh, I'm sorry, this is A, right? Let's use this example, okay? From O to A, but if A doesn't graduate law school, O has the right to reenter. So everyone see the difference, right? I'll make this in 3 years, so it's believable. Okay. From O to A, but if A doesn't graduate law school in 3 years, O has the right to enter. So what happens here is that A gets it right away. A has it immediately. But if at some point in the future, 3 years, he doesn't graduate law school, right? O can come back and retake it. O has the right of entry. The difference here is that after A dies, B only takes it if he's already a lawyer. The condition comes before. The trickiest part here, when you're deciding if it's a vested or contingent remainder, is there a condition precedent, right? Precedent. Well, this is right here. Let me manage it. This is a condition precedent, right?
Because it's before O.
Before B gets it.
I'm talking about the other.
The first example, right?
Graduate law school.
This is a condition subsequent, right?
That's what I said,
Right, yeah. So A, we say A has a fee simple, subject to condition subsequent. And then O has the right of entry. This is exactly what we did 5 minutes ago. But when a contrast is this is what a condition subsequent looks like. This is condition subsequent, and this is condition precedent. Everyone see the difference? The condition subsequent comes after you get it. The condition subsequent kicks in after you get the land. The condition precedent must be satisfied before you get the land, right? In other words, B doesn't become a lawyer. B doesn't take anything. He never gets Blackacre.
So the condition subsequent is a vested remainder.
Yeah, No. Let's be precise. Okay, let's go back up here. In order for something to be vested, both these have to be true. It has to be an ascertained and no condition precedent. Okay. What if one is true, right? Right? If either 1 or 2 is false, right? Then it's called contingent. If either of these are false, it's no ascertained person, or it is subject to condition precedent, then we call it a contingent remainder. What you have to do in your head is when you see a life estate and then it goes to a third person, you say, okay, that's a remainder. What kind of remainder is it? Is it vested or is it contingent, right? Here, I'll walk you through the thought process, which, and again, this is not intuitive. It's actually quite unintuitive, right? So you say first, like, look, okay, so it's a life estate plus an interest to a third party. Okay, so I know it's remainder, right? And then you say, well, is it a vested or a contingent remainder? Which one is it? So you say, okay, is it ascertained? Or is it ascertained? Yes, okay. Then you check, is it, what's the other one? Condition precedent, say yes, and then it's a vested remainder. Okay. Let me put this all on one page so you can see it easier. Right, so this is your thought process, right? So you see it's a life estate and then interest in some third party. Okay, so you know it's remainder. Okay. Then you say, is it vested or contingent remainder? So you ask, is the third party ascertained? Yes. Okay. The person's named. Is there a condition precedent? Actually, this should be the answer. Is there no condition precedent? Right. Make sure there's no condition precedent. The answer is yes. Then you have vested remainder. Right. Otherwise, it's contingent remainder. Remember, vested remainders are certain to happen. Contingent remainders may or may not happen, right? But you need to answer these 2 questions. These will get you the right answer. Don't just say, well, this may or may not happen. That's not enough. You need to have these 2 things satisfied. Okay? These 4 steps is the way you need to walk through these problems. Ashley?
Either or is yes. Or
Both of them have to be yes.
both of them have to be yes. Okay, I just wanted to-
Yes, vested remainder is both yes. They both have to be true. You need both conditions satisfied. If either of them are no, then it's a contingent remainder.
You might have already covered this part of the but can you give us an example of when the person is not ascertained?
We're going to do a bunch of examples in a few minutes.
Okay.
That's the rest of the class. Examples. Other questions in this? You read the notes. There are a lot of examples we can walk through. Other questions? Everyone get this? All right, let's try some examples. Restart. Okay, so let's try this one. This one's actually from the examples explanation books, which I like. So O to A for life, then to B and her heirs if B marries during A's lifetime. Okay? Here's an example. From O to A for life, okay? Then to B and her heirs if marries during A's lifetime. Okay? So let's walk through this one clause at a time. I guess, Jason, you're next. So how would we characterize A's interest here? Yeah, that's the easy one, right? Okay. So now, when you see life estate and it's going to a third party, what do we know the future interest is called? Okay, so we know it's remainder. We don't know what kind of remainder it is, right? It could be either vested or a contingent remainder. So Jason, what are the 2 questions we ask ourselves to determine if it's vested or contingent?
Is it ascertained by the person ascertained?
Okay, so is the third party ascertained?
Yes.
How do we know that?
Is it-
Yeah, B is named, and this is the easiest way to do it. When a person is named, right, they're ascertained. We're going to do other questions where you say to B's children. We don't know who those children are. That person doesn't exist, right? If a person's named, they're ascertained. Okay? All right, Jason, then what's the second question we ask ourselves?
Is there a condition precedent?
Okay. So let's read this very carefully, right? Then to B and their heirs if B marries during A's lifetime. Okay? What are the circumstances under which B will ever take it?
Be married during A's lifetime.
Right. Once A dies, can B ever satisfy that condition? Okay, everyone see that? Once A dies, right? B can never, ever, ever satisfy that condition unless he's already got married before. So the only time for B to get married is when, Jason?
When B marries during A's lifetime.
Before A's death.
Before A's death. Yeah.
Exactly. So basically, the condition is B has to marry, and then the key word in the sentence is before A's death. And is this a condition precedent? Yes. And it's an easy condition precedent because it happens before A dies, right? So if A is already married during, if B's already married during A's life, then he gets it, no problem. If he's not, then tough luck. And then Jason, let's round it out. What's O's interest here? Oh, what happens?
O's interest would be,
What happens if B never gets married?
O has
Yes, and how do you know it's reversion?
because O is a grantor.
Yes. I mean, see how this builds upon each other, right? You remember that the interest in the transferor is called reversion, right? This is like from O to A for life. You know that O has reversion. That's effectively what happens here. If this condition is not met, just strike it out. So O would actually get it back as reversion. You see how these get really tricky very quickly. So now we have the interest in the transferor. We have the interest in the third party. And then we have the interest in the transferee. Right? We have these three different people who each have competing interests at any given time.
Would O's interest be possibility?
No, don't say that's not a word.
Oh,
No, I'm glad you said it.
I'm sorry.
No.
Just because he may not.
There's no such thing as a possible reversion. That's not a word. But every year someone says it. So I'm glad you did. Okay? Do not say there's a possibility of reverter, right? But what is a possible reverter matched up with? Which present estate? Yeah, well, you said it. What is it?
Fee simple determinable.
When you have a present fee simple determinable, right, the possibly reverter goes to a third party. Here, it's what's the interest of the transferor, and we call it a reversion, period. No possibility. It may or may not happen. Like, linguistically, you're correct. There's a possibility it may happen. There's a possibility it won't. But it's simply called reversion, period. So I hand somewhere, yeah.
Yeah, I was gonna say like in like technical language, like the possibility that it occurs.
It may happen, it may not, but you just call it reversion.
If a certain event happens, then reversion will
Yeah.
certainly happen.
Exactly. Yeah.
I
Jason?
was gonna say, because it's a contingent remainder, it just makes sense that it would be a reversion if the contingency doesn't happen for the remainder.
Right. Yes, and we'll finish this. I forgot to write it. B has contingent remainder. Right? Everyone see that? Yeah, in the back?
If you want to be super specific about these interests, you say you have a future remainder interest.
Yes. Yes. Contingent remainder and fee simple. You don't need to say future because it's some kind of redundant. The remainder is always in the future. But you can say contingent remainder and fee simple. That'd be the A plus way of writing it. By the way, and I'm just going to anticipate a question on the exam, right? People always ask what's the difference between an A and a B paper, right? The B paper will say remainder, right? The B plus paper will say contingent remainder, and then the A paper will say contingent remainder and fee simple. So you can see you layer on different things, tell me you actually know what's going on. And I'm anticipating that question. That's an example, right? The B paper will say remainder, and then B plus will say contingent remainder, and then the A paper will say contingent remainder and fee simple, and give all the rationales why. So you need to know each. Yeah.
Okay.
it always remainder in fee simple?
No.
'Cause it could also be like,
I mean, you can make a really what if A doesn't start off with a fee simple, right? I mean, what happens if O doesn't start off with a fee simple?
but A doesn't, wait, A doesn't.
Are you asking about O or A?
I'm sorry, I'm doing that. B has a contingent remainder in fee simple.
Yeah, it doesn't have to be. What if then to B for life, if B marries,
Has a contingent remainder in-
whatever it happens to be? Yeah. In this case, it's fee simple because it's enter heirs.
But if it said for life, then it would be contingent remainder in life.
Yes.
Professor Boydman, I'm a little confused on an example there with O to A for life and to B and her heirs if B marries during A's lifetime. Because we answered that, what is it, that there's a condition precedent. But are we looking mainly at the fact of the death? Because I thought.
Death is not a condition precedent. I put this in notes. Death is never a condition precedent. Death is natural, right? I'm talking about a condition under which B gets it. So even here, I mean, you can use the commas as a crux. There's no comma. It says, then to B and her heirs if B marries during A's lifetime, right? B takes nothing unless B's already married. That's the condition before B gets it, right? The condition comes before B receives the land. Does that clear up your question?
Well, it seems like we've got question 1 from vested remainder and question 2 from contingent remainder that both are yes, but makes it a vested remainder.
They're not both yes. The answer to the question here is there is a condition precedent, right? In order for something to be vested, and here, let me go up here, there has to be no condition precedent. To be a vested remainder, there has to be no condition precedent.
Right.
When there is a condition precedent, it's a contingent remainder.
So a contingent remainder then can ascertain who the person
Yes.
is. Okay.
One of those has to be true, right? To be a vested remainder, I'll write this very clearly. Whoops. Right? To be a vested remainder, both have to be yes. Right here, big bold letters. To be a vested remainder, both have to be yes. Ascertained and no condition precedent. If either of those is no, then you have contingent remainder.
In contingent remainder, do you need both? Or one of
One is
of
enough.
the two?
One is enough. Start off by saying, is it vested? If the answer is no to either one, then you know it's contingent. They both have to be true to be a vested remainder. Lou?
So with O as a reversion,
Oh,
O has a future interest of reversion in that instance. Is there a difference? Like, do we care? Do we say that in one case the reversion is contingent?
No, don't ever say that.
Okay.
Just say reversion, period. No adjectives, just
So
reversion.
we don't care that, like, in some cases it will definitely happen.
Doesn't matter. It's called reversion. That's
Okay.
it. Don't use adjective because you'll get yourself confused. Jason.
O will have, if I'm understanding it correct, O will have a reversion unless they give fee simple, right?
Well, they didn't give fee simple. So what did O actually give? O gave a life estate to A, and they gave a contingent remainder to B.
Right.
Because it's contingent, it may never happen, and O keeps reversion in the background.
Yes, but what I'm saying is O is always gonna have reversion unless they give the proper.
Well, but the reversion is only when it's being followed by a life estate. And don't get too far ahead of yourselves. We're only talking about starting off with a life estate. In class next week, or whenever it is, we will do where it's not with a life estate. Then it gets a little trickier. But whenever O starts off with a life estate, you have reversion. Really, I mean, you can say it like this, right? So you go life estate plus a contingent remainder. Grantor has reversion. Yeah, okay, so let's do that one, right? Life estate plus vested remainder. What does the grantor have there? Grantor is nothing. And I'll show you an example of that. Right, so like, watch. So from O to A for life, then to B and his heirs, right? This is the example we've done 100 times. Amanda, is there any circumstance under which O gets it back? Nothing. When it says from O to A for life, and to B and his heirs, right? There's no circumstance which O gets it back. O has no interest. Everyone see that? Yeah.
Everything would be a vested remainder, right?
Yeah. Let's try example 5 in the book, if you bring it up in your notes. If someone has a page, just call it out. Yeah, that's it. Okay, there we go. And it's up here. It's up here right now. All right, so where was I up to? All right, Sonia, just read the first sentence. Don't read the answer. I hate how they put the answers right away because it makes it so don't read the answer. We just read the first sentence. Yeah. Okay, stop reading. Okay, don't keep reading. All right, but we'll pretend as if the answer's not there. Okay, so O to A for life, right? Then to the heirs of B. So let's walk through this one, right? What is the present estate? A is a life estate. All right, so we know when the present is a life estate and it goes to a third party, what's the future interest called? Okay, now say what type of remainder? Okay, so we have 2 questions, right? The first question is okay, so you fell for the trap. Who is the third party here? Is it B or B's heirs? Ah, when do we know who B's heirs are, Sonia? Exactly. We only know B's heirs when B dies. So, Sonia, are B's heirs ascertained? No. It's almost like a trick question, right? You see B's name there, but it's not to B and his heirs. It's just to B. Everyone see that, right? Take a look at, let's try example 4. Actually, I don't want to try example 4 yet. Okay, let's try example 6, which I think is on the next page. Okay, Ava. Oh, sorry, Elizabeth. Go for example 6, please. Okay, and don't read the answer, please. Okay, so it says from O to A for life, right? Then to B and her heirs if B survives A. So again, what's the present estate, Elizabeth? Okay, it's a life estate. Who is getting the future interest? Some third party, right? So what's the future interest called here? What, just broad? Remainder. Okay, good. So we ask ourselves, is this a vested or a contingent remainder? Okay, so let's look for our 2 questions, right? So is the third party ascertained? Yes. So is it ascertained? Okay. Is there a condition precedent? What is the condition precedent? Let's say it louder. Yes. B has to survive A. This is no different than B getting married during A's life. It's the same idea. The condition precedent is B survives A, right? Elizabeth, so this is a condition precedent. It's condition precedent, right? So is this a vested or a contingent remainder?
I'm sorry.
Which one? If you ever forget which is which, the word vested means certain, the word contingent means uncertain. So which one is this? This is a contingent remainder, right? Even though the third party is ascertained, we know who this person is, B, he has to outlive A. That may happen, that may not happen. This is a contingent remainder. Yeah.
So we don't assume, like when you see a life estate, like if it just said to O to A for life, then to B and for heirs, if B survives A wasn't there,
Then it's vested.
then it's vested. But it's
Yeah.
because it is written there.
Yeah, I mean that's the yeah, I mean that's the rub, right? Because that condition precedent's there, that renders it a contingent remainder. Yeah. Is your hand up?
No, I'm just kind of analyzing, so basically the condition is that A has to die before.
Yes, exactly right. A Or you can say it better, B has to outlive A. Well, death is natural, but you're saying who's dying first, right? Right. So anyways, that's a condition.
But
Yeah.
for B's heirs, if B passes before A, his heirs are cut out of the loop.
Yes, because it says B survives A. That's the specific condition precedent. Everyone get that? All right. Everyone okay? Yeah, in the back?
So O has a reversion, right?
Yes! That was my next question. Beautiful. Perfect. Why is O reversion?
Possibility that.
Don't say possibility. I swear, it's every year this happens. There's a chance. See, no, but see, the exact, you guys are the same wavelength, you're like ESP, right? So there's a chance, right, that O gets it back to O's reversion. Whenever you have a contingent remainder, the grantor always retains reversion. I don't mean to jump, I don't mean to yell, but I don't want anyone making that mistake in the exam, and this little outburst perhaps might burn in your retina, that don't say possibly reversion. I think I warned you last week someone would say it, and then it took exactly one class for that. So, yes, so that's right, yeah.
On the exam, would you, explain how O would,
Yeah, you say in this case, because B died before A, O has reversion, and O gets it back. Yeah, that's the answer. All right, there's one concept in the book they mention, which I don't want to dwell too much on because it's kind of not too important, but it's called a vested remainder subject to open, right? And what this effectively means is you can leave a gift to a class, right? So say like this. Let me get a good example. Okay, here we go. This is example 4. If you go a couple pages up, I think it's there. Here we go. It's on 282. Okay. So it says, O conveys to A for life, then to A's children and their heirs. Right? So let's walk through this one. Ava, let's walk through this one, right? So what's the present interest called? Beautiful, yeah. A as life estate, okay? Then what do we know the future interest is called? What's the general umbrella? Good. The future interest is called remainder, okay? So is it vested or contingent, okay? So is the party ascertained? And sorry, I didn't read the next sentence, but A already has one child, B. So we know that A has a child named B. So is the third party ascertained in this question? You said, I'm sorry, you said yes? That was like, no, yeah, what? Which one is it? Yes? How do we know that the third party is ascertained? How do we know this? Yes, right? When you say the children of A, right? And we know A as a child at the time, this person's name is B. You will always have that information. Well, I'll give you that example in a minute. But let's deal with this one first, right? I tell you, at the time of this grant, A already has one child, the name is B. Is that person ascertained? Okay. And the easy part, are there any condition precedents here? You're right to say it. Right. There are no condition precedents. But we all know that people are fertile and they can have more children, right? A has one child, B. Could A have other children? C, D, E, F, G, right? What happens if by the time A dies, he has 8 children? How many people will be in that class? You got it? Who is he leaving it to A or to his children? To his children, right? This is a very specific thing people put in their documents. They don't know how many kids they'll have when they die, right? They simply say, I want to leave it to my children as a class. That class may open up and add a lot more people, right? Whenever new kids are born, right? Going Maury Povich, like, hey, you're my kid also, right? So you can have more possibilities of people adding to that class. So this is what's called a vested remainder subject to open. It's such a horrible phrase that I don't know why they call it these things. But it's a vested remainder subject to open. Right? What does that mean? It's vested. How do we know that? Because parties ascertained, we know about B, number one. And number two, there's no condition precedent. But at some point, there may be more children. The class may open up. So we call this a vested remainder subject to open. Okay? Everyone get that? All right. Andrew, James?
Yeah.
Let me ask you this question. What happens if A is an 80-year-old woman? Right? A is 80 years old. Does she have any more kids?
No.
So would we still say she may have more kids in the future?
No.
Okay. So in reality, the answer is no, right? Even today, an 80-year-old woman, the marvels of fertilization drugs, is still not going to have a kid. But we are in fictional property land where there's this concept, and I'm going to write it out because this will be burned in your retinas forever. The fertile octogenarian. I swear to God, this is a real thing. The fertile octogenarian. In property, we assume that an 80-year-old woman is still fecund. She can still bear children. So no matter how old you are, as long as you are alive, we assume you can actually bear more children.
Could they adopt?
Keep it clean.
Because they could adopt a child?
No. This will be children of your blood. This is your, as this was written, I mean biological children. This is not, adopted children don't take under the normal course of circumstances. There's a different rule for this. So they natural children, natural born children. Right? So we assume that even if A, in this case, is 80 years old, right? A can still pop out more babies. Right? You'll never forget this. You'll forget everything I say, but you remember the fertile octogenarian. This is burned in your retinas, okay? So no matter how old you are, someone can always give birth to more kids. The magic of IVF comes to property law, right? So this is called the vested remainder subject to open. Okay? All right, now I want to answer Amanda's question, which I somewhat ducked, right? What happens if A has no kids at the time of this grant, Amanda? What do you think happens? A has no children. That's right. If A has no children, right? If A has no children, no one's named. We don't know about B. At that point, there's no ascertained third party, and it's a contingent remainder. All right, so the vested is subject to open. Basically, the rules, if like one child is named, then it's vested remainder subject to open. And if no children are born, then it's contingent. More or less, that's a shortcut way of describing it. Questions? I think you're struggling about asking a question.
Well, I'm thinking about, if I'm ahead or whatever, please tell me. If we change the word from children to heirs, because
That's
our words
different.
are so, but
That's
that's the potential
different.
because a 90 or anybody, they can name heirs at any point.
This is specifically children. This, with the subject to open, it will almost always be children. I mean, you can even make it to your adopted children if you want to say that. But usually children mean biological, natural children. Right? Doesn't have to be from the same daddy either. It could be from a different baby daddy. But it just be, your children. It's true. Yeah.
I don't know if you've already answered this, or maybe I just missed it, but is it still a vested remainder if there are named heirs and it's a condition subsequent?
You won't ever see something like that. That will not happen. It's impossible.
Okay.
Don't worry about it. If you do that, it'll be something totally different. That's not what we're talking about. Okay. Let's try the review question at the end of the chapter. There are 4 of them. We can try maybe doing 1 or 2 of them in our time remaining. It's on page 283. Okay, so here on Baby Dude, I'll skip you. Philip, read question number 1. You got it? You want to?
Right, why not?
Go for it. Okay. Yeah. Everyone, he had a baby the other day? Oh, baby on the way. I thought the baby was born. Okay. Oh, you look so bleary-eyed. I assumed the baby was born already. Oh, well, that's why I shook your hand. I thought the baby was already born. Okay. All right. Well, you'll save the pass for that. Okay, so go for it. Sorry. Yeah, just go for number one. Okay. So this one's actually like almost like a little bit of a trick question. Okay. What's A's interest here? What's A's estate? Okay. What comes after a life estate when it goes to a third party? Not fee simple. What do we call the future interest after a life estate? Yes, a remainder. Okay, good. There's a remainder that comes afterwards. All right. Is this a vested or contingent remainder? So we ask ourselves, is the third party ascertained? Is the third party named? Who's the third party? Yes, B. Now here comes the tricky part. Is there a condition precedent? This is a trick question. Why not? That's right. There is no condition precedent. Why is there no condition precedent? Yeah. So this is redundant. To A for life, right? Then, I'm sorry, to A for life in the event of A's death. That's redundant. There is a 100% chance that after the A's life estate's over, A will be dead. So this would actually be a vested remainder. Okay. Yeah, sure. Okay. Let me walk you through question 2 because we're running a little bit short on time, right? So it says, O conveys to A for life, then to B for life, then to C and her heirs. So when it gets messy is we start stacking one on top of another. So now it's not just OAB, it's OABC. So we know that A has a life estate. That one is straightforward enough, right? B will take a vested remainder. Why is it vested? Because he's ascertained, right? And there's no condition precedent, okay? And then what about C? C also has a vested remainder because C is ascertained and there's no condition precedent. So you can actually have 2 vested remainders stacked one on top of each other. And because they're vested, O has nothing. O has no interest. Chad? Is there a question? Okay. Let's do question 4. Question 3 is a little. We'll come back to question 3 later in other context. Okay. So we'll finish with this one. It says, O conveys to A for life, then to A's children, who shall reach 21. And it tells us that A's oldest child is B, 17. All right. So we know that a child is named, a child is in existence. So we start off that A has a life estate, okay? And we know that A's children have a remainder. So is it vested or contingent? Because a child is named, B, we know it's a vested remainder, and there's no condition precedent. Oh, I'm sorry, I said that wrong, okay? There is a condition precedent, though, isn't there, right? You have to reach 21, right? The children only get it if they reach 21, which is no guarantee. Even though B reaches, hold on, did I do this wrong? I think I'm going too fast. Let me be precise. So what happens when I go too fast, I go too quick. Okay. So at the time this is written, B is 17 years old, right? At the time it's written, it's not clear if B will ever hit 21. So at the initial outset, it's actually contingent. But after B turns 21, it becomes vested. Yeah, that was it. Sorry, I flipped it in my head. Initially, when B's only 17, it's contingent. But once B turns 17, right, a child reached 21, it becomes vested.
And A's still alive.
A still alive, yeah.
So in that case, if A dies when B is 19.
Too bad.
So it's reversion or
Reversion to O.
does B get it when
O has reversion until B reaches 21. Once B reaches 21, it becomes a vested remainder. And if you want to be really precise, I'll end with this one. It's a vested remainder subject to open because there may be more children who can live to reach the age of 21. Right? So it's actually a vested remainder subject to open. Okay. If you have a question, come up. But everyone else, have a wonderful day. We'll do more of this in class next Monday. But thank you very much. You did very well. If I can comment to you, you went up and down the road very well. So I say A+. Very good.
So